Ta-da!
Aloha, Commissioner Hatch.
Thank you. Aloha to you. Sorry about the technical failure. Sorry, my fingers.
No problem. We're about to get started. All right. Good morning, everybody. Ms. Linker, go ahead and take the roll.
Commissioner Cardenas?
Here.
Commissioner Hatch?
Here.
Commissioner Hayward?
Here.
Chair Matich?
Here. All right, we'll proceed to item 1. This is public comment for items not on the agenda. Do we have any persons here today that would like to speak? Good morning.
Great, thank you. Before I speak, I just wanted to publicly recognize the FPPC staff that have worked with me in the past couple of months, and they've been very patient, and their professionalism has been very high, specifically Sasha and Director Jones. So I just wanted to make sure that you were aware of that. You received a number of comments from people in my neighborhood. Hopefully you've had a chance to read them. On November 1st, by the way, my name is Scott Vaughn, for the record, and I'm from Placer County. On November 1st, FPPC Director Thomas Jones issued a response to the appeal of the decision on my sworn complaint, stating that due to insufficient evidence, the Enforcement Division could not conclude that Placer County Supervisor Kirk Euler had a disqualifying conflict of interest to require disqualification from governmental decisions. Yet he voluntarily left the room under the pretense of being absent and subsequently abstained, which is sufficient evidence that he knew that he did have a conflict of interest. At no time on either of the meetings did Supervisor Euler disclose his potential and/or actual conflict of interest. In a subsequent phone conversation with Director Jones, he acknowledged that the FPPC does not condone Supervisor Euler's actions. There is more information that could shed light through an investigation by the FPPC. An amended complaint I submitted last night was submitted regarding the supervisor's conduct, failure to disclose specifically, which I did not mention in my first statement, potential actions of the county to aid and abet, and whether this has created a situation within the county where individuals fear reprisal. And as you know, the only way that we heard about this in the first place was through a whistleblower anonymous mail thing. And you've gotten a copy of that, hopefully, that I emailed the statement that was there. It stated that there was further information through human resources. Thus, this information would be helpful and informative in the matter, which could be secured by the FPPC through its investigative powers to really do a thorough investigation. The basic definition of absent is not being in a place, occasion, or part of something, to go away and remain away. Mr. Euler remained as part of the board on the day of the vote. It is highly unlikely that he even left the building, since he was only gone 10 minutes. The term absent is not defined in the Political Reform Act, nor in FPPC regulations. Being temporarily absent is also not defined in the Political Reform Act or in FPPC regulations. Stepping out of a meeting for 10 minutes is a statutory requirement of the Political Reform Act. They have to leave if a vote's taken or discussion of the topic. The section is 871053. It states that for financial conflict or interest, the official must leave the room for the duration of discussion and or vote on the item. The FPPC never contemplated a temporary absence when considering the absent clause in the conflict of interest regulations, as its interpretation is in direct conflict with the act.
Sir, your time is now up. Go ahead and take a minute to briefly conclude.
Okay. Well, I guess I want to finish the whole thing by saying that I would like you to open up an administrative investigation. You have the powers to subpoena. We have gone and we've tried through a PRA, and over the years, we've PRA'd the county multiple times, and we've never received any responsive comments from the supervisor office. You have the power to go ahead and do this. You have to have the courage to act. So I would appreciate a follow-up from the FPPC on some way, or maybe adding this to an agenda item in the future. Thank you.
Thank you. And I'd like to take this opportunity to thank you for the multiple times that you've come and raised these important issues with us. So that the public is clear on this, I'm not going to comment on any pending enforcement complaint that you've made that would be inappropriate. But I think folks should know that there are at least 3 things that have been raised in your comments that we are addressing affirmatively. First, the question of with respect to when a conflict of interest exists, particularly when you have a public official who has a family member and that family member is implicated in a decision. We, in December or shortly thereafter, are going to be considering some changes to our regulations that would address some of the concerns that you've raised. So again, thank you for raising that. We are taking action there. Secondly, with respect to the time and manner of disclosing when there is a conflict, that is an issue that I think the Commission may take up at our regulatory calendar in December or possibly in January of this year. So again, that's an issue that you've brought to us and that we are going to be examining and taking action on. And finally, I would just commend to you that within our packet today, we actually have an advice letter on 1090, which is a separate body of law with respect to conflicts of interest, which addresses specifically whether the Board of Supervisors in Placer County can approve promotion for Mrs. Euler, given her husband's role on the Board of Supervisors. And as I think you've probably read in that advice letter, we have advised that they cannot do that under 1090. So in 3 instances, we have, I think, taken some action to address the concerns. So again, I want to thank you for bringing them to us. We're doing the best that we can.
Is that 1090 available online?
Yes, it's part of the agenda packet.
Thank you very much.
Yeah, thank you. Any other public comment in person? Any digital public comment? All right, moving on to item 2, approval of the October 2019 Commission hearing minutes. Do I have a motion?
Move to approve.
Second.
Any discussion? Any public comment? Seeing none. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
Moving on to our enforcement consent calendar. These are items 3 through 15. Do we have a motion to approve the consent calendar?
I have a question on an item, number 15.
Number 15.
We're going to be able to pull some items?
I think procedurally we will call the motion, have discussion, then call for public comment as our normal practice. So do we have a motion to approve the calendar before discussion?
So we're doing this where we're approving the calendar and then we're able to pull items and talk about them? I'm a little confused.
Mr. Jones, can you walk us
It's
through
slightly different from I think how we've done
Robert's
before.
Rules of Order?
Procedurally, if you call the motion for the consent. Oh, apologies. If you call the motion to approve the consent calendar, somebody can make that motion, even if that person ultimately doesn't vote for the motion. The discussion of the matter will come after the motion because the discussion is on the motion itself.
Yeah, I agree that's more typical Robert's rules, but it's slightly different from how we've been doing it, but that's fine. I move approval of the consent calendar.
Second.
All right. Commissioner, discussion of the consent calendar.
I would like to talk about 3, 4, and 5.
All right. And Commissioner Hatch, I believe you wanted to talk about item 15?
Item 15,
Okay.
correct.
With your indulgence, perhaps we can have Commissioner Hayward begin our discussion.
Okay, thank you.
Certainly.
Yeah, so 3 and 4 are both personal use matters. Matter 3 is a particularly egregious one. And I guess I wanted to talk generally, hopefully this will send a signal to the greater world out there, that I find personal use matters particularly bad. What they do is they show that a person who is raising money in trust for a political purpose is then converting that money to personal income, basically. What a wonderful thing to be able to do. Ordinary people can't do it, though. I mean, you have to have a committee or a PAC and then abuse that committee to have this kind of largesse. And I think when you look at it that way, it's particularly repugnant because here's some political activity going on that is not about moving the country forward. It's not about engaging in political debate. I mean, people get, upset about, independent expenditures and super PACs. Well, at least they're talking about issues. This is almost the opposite. It is taking resources that were supposed to be doing that and sucking them into somebody's personal lifestyle. So there's 2 things about personal use. First of all, it's misleading the donors and has sort of a smell of fraud to it. And then there's the tax evasion. I mean, we all know enough history to know that sometimes it's not the actual crime that gets people, in prison, but the tax evasion that occurred ancillary to that crime. And so I just, wanted to make those 2 points. I'm happy to see the size fine we have in matter 3, although I think there are people who think it should be even higher, when we do these things administratively, there are certain caps we have to observe. And I think that might have come into play here. And so that's it. That's all I wanted to say about 3 and 4. Shall I go on to 5?
Well, actually, if we can,
Or we're
just
gonna stay
pausing on 3 for
Okay.
a second. I just wanted I absolutely agree with everything Commissioner Hayward just said. And I just wanted to commend the work of our investigators and our auditors. I think oftentimes, we forget the fact that there's a lot of work that goes on behind the scenes that uncovers these types of things. The FTB auditors, our investigators, and of course our enforcement staff. I think this is a very important area for us to be focusing on. It's clearly should be and should continue to be one of our enforcement priorities. And so I just wanted to recognize the incredible work of our staff on this. Commissioner Cardenas?
Thank you, Mr. Chair. I'd like to align my thoughts with what I just heard from my colleagues. This is a spectacular fall from grace by this particular individual. Among other offices, I guess, former member of the Assembly. This gentleman took office in 1973 at the age of 17 to serve on the Pittsburgh School Board. Turned 18 right before he's sworn into office. And then he elects to end his career in this manner. It's a breathtaking arrogance. Ms. West, did the individual fully reimburse the various committees out of which he took money?
Galena West, Chief of Enforcement, he did. He fully reimbursed the $130,529 and then paid the $150,000 penalty on top of that.
The $150,000 penalty assessed by this commission, how much of that is the individual paying versus any combination of committees?
Half, $75,000 had to come out of his personal funds.
There are particularly egregious issues here which appear to go, at least on their face, beyond mere civil law. Are there any other avenues for the public to see some justice here?
Certainly. We referred this to the district attorney's office. There are some difficulties when it comes to personal use rules. The legislature has exempted them out of a lot of criminal prosecution. And so usually these are prosecuted as perjury counts.
I want to share the chair's concern here. Terrific work by your staff. Thank you.
Thank you.
Right. Commissioner Hatch, anything on item 3 before we move to item 5?
Yes, if you would mind. I personally watched for years the Sacramento Bee browbeat the legislature with listing what they consider to be abusive uses of campaign funds until the legislature finally gave in and passed this law that Galena and her team has been enforcing. I'd say great job. It's about time that some of these are brought to justice. Thank you, Galena.
Thank you. It was a team effort. We thank FTB for starting us down the road and all of the hard work that they put into this. And then Bob Perna and Neil Bucknell really took the reins on this case and pulled all the strings and traced all the commingling cash, and they really did a great job.
Thank you.
Thank you, Galena.
All right, Commissioner Hayward, would you like to move on to item 5?
Yes, thank you. And then the one thing I wanted to mention about item 5 is it's an example of something that we don't see every meeting, which is the FPPC coming up with an agreement that involves not just the Political Reform Act, but the law of a county. So as people might or might not be aware, we have now been opened up to being the enforcement and interpretive legal body for pretty much any city or county that chooses to negotiate a contract with us. So this is an example of a San Bernardino one. We've had this similar relationship with San Bernardino for a while. And I guess I just wanted to bring that to everyone's attention. I think it's going to be moving forward an interesting challenge to see how, as we take on the law of different counties and cities, how we ramp up that expertise sufficiently quickly with the constraints we have in terms of being able to ramp up hiring and budgetary issues and other issues like that. Anyhow, that's all I wanted to say about that. I just wanted to call it to people's attention that it's a slightly different thing than what we usually see.
Thanks. That's important. Any other commissioner comment on item 5? Hearing none. I think we skipped item 4. Didn't you also want to talk about 4?
It was just grouped in. It's another personal use.
Okay. All right. Commissioner Hatch, you wanted to discuss item 15?
Yes, I just had a couple of questions, actually 3, I think. On this default proposal, have we had any last-minute response from the accused?
We have not had any communications from Mr. Murga.
Okay, thank you. And I just may have talked about this in the past in the context of another item, but what happens if he doesn't pay?
Right. Then we get a judgment, and the judgment is then enforced where we put liens on property, and we do the FTB tax intercept program where any tax returns are then intercepted to pay down the penalty. We have not looked into strengthening those efforts to include wage garnishment and other options, but those are options that we can look into in the future. Just mostly a staffing issue as to how much resources we want to put into trying to get money that we're owed. So it's a resource issue.
I know this is a fairly small pool of cases, but you have a sense of what the historical experience has been in terms of success of collecting?
It's been transferred to the administrative division to track that, but I believe the tax intercept program is quite successful.
Okay. Thank you.
$100 increments or.
All right. Any further commissioner comment on the consent calendar? Hearing none, we'll take public comment this time on the consent calendar. Public comment from individuals in person who wish to speak.
Thank you, Commissioners. My name is Kenji Yamada. I'm a Contra Costa resident. I'm commenting on item number 3 in the consent calendar. I first want to thank FTB and FPPC staff for getting to the bottom of this case and getting the facts and putting them in front of the public. I know it took a lot of hard work. I was a candidate myself for office in Contra Costa last year. The ethics and requirements of the law were not hard to observe, and as you've all correctly observed, it's pretty outrageous that our local elections official violated these rules in a very willful way. Making this case painful for Mr. Canciamia is the point. We need a deterrent, a stronger one than we've seen in previous cases. I know staff, discussed extensively the case of our former district attorney in the stipulation. What we would, those of us, who are here from Contra Costa would like you to do is unfortunately reject staff stipulation agreement, which charges Mr. Canciamia with fewer counts than possible in order to get him to waive his right to judicial process. I understand that's sort of the trade-off offered there. We would like you to reject that agreement and instead direct staff to seek the maximum number of counts for the maximum penalty. And that is not for the purpose of revenue, it is for the purpose of deterrence and making this case as painful for the offender as possible. We are hoping also that there will be criminal charges brought by the district attorney. Of course, that's outside of your purview, but I hope you will not approve this consent item to approve the stipulation agreement, but instead will reject it and direct staff to seek the maximum penalty. Thank you.
Thank you. Do we have any further public comment on the consent calendar?
Can you hear me? Okay. I'm also from Contra Costa County, and I echo everything that my friend Kenji just said. about rejecting this deal. It looks like I'm supposed to pay his pension of $122,000 after he's done this to me and the other voters. Is that part of the deal? Did I understand that? And I feel it's getting harder and harder to have faith in the political system because of so much fraud and so much inability to decide if we can even trust our candidates. But I think this will be a great deterrent for people seeking office to realize it's not just about they can't get away with it, and so they'll have to comply with the rules. So thank you for reconsidering this.
Thank you.
Good morning. My name is Cora Mitchell. I'm a resident of Contra Costa as well. And I want to echo what they said and just let you know that our political scene at the local level has been in a stranglehold of corruption for a very long time. We just recently saw a similar instance with our district attorney. Joe Cancelmia wasn't just our election registrar. He ran to be a judge. These are people who are supposed to understand the law, and he stole. This is a basic, it's not just a matter of law, this is just a basic moral issue. You don't take things that don't belong to you, and if he could do something as egregious as this, how am I supposed to have faith in any of the elections that he oversaw, knowing that our political network in Contra Costa County is all about I scratch your back, you scratch mine. It just really makes me question how legitimate the elections were that he oversaw. The corruption is so bad in Contra Costa that our county tax assessor is on trial right now, and he still feels empowered enough to launch a campaign for Board of Supervisors. That's how bad it is that these guys don't even bat an eye at the way that they behave, and it just keeps getting swept under the rug. So I would prefer, as a resident of Contra Costa, to reject this deal and charge him with as many counts as possible. He didn't just steal the money. He lied when he was caught about it. He doctored bank statements. This is not somebody who feels bad about what they did. He needs to be made to feel bad. He retired before this came to light. I don't think that's okay. And a message needs to be sent to the rest of the elected officials in our county that this will not be tolerated. If you start picking names out of hats of people who are currently seated in elected positions, you're going to keep finding this kind of corruption. It's that rampant. And we all know it, but there's nothing we can do about it because these guys keep getting put into these positions. They're appointed to these positions. When they're running for election, they have these big banks that are backing them, these big businesses that are backing them. We can't compete with that as residents. So I'm asking you to please reject this and charge him with as many charges as you can. He needs to face the maximum penalty possible. Thank you.
Thank you.
My name is Graham. I'm also from Contra Costa County. And I like to say that in general, a lot of our politicians are forthright and upfront, and they don't try to swindle our money. But when we do have that happen, unless our penalties are a lot more higher than what they are today, this continuing embezzlement and other misuse of funds will continue will continue. And we need to set a message to them. And the only way they can set a message is actually increasing the amount of fines, not just the $5,000 per violation. That should actually be double, triple, or even 10 times that. But so far, a lot of our politicians are getting away with it. Like I said, in the past, you had Mark Peterson, who was our DA in our county, who swindled money, and he got a slap. He got maybe a $66,000 fine. And these folks are making over $200,000 a year. Just $150,000, that's a drop in a bucket. And they should not be even getting their pension. If I was in private practice and I was working for an employer and I took money away from them, I wouldn't get my pension. I'd be fired and out the door with zero pension. This is what should be happening to our political office too. It's taxpayer money, our money, your money. Thank you.
Thank you.
Political office, taxpayer money, our money, your money. Thank you.
Hi.
Hello.
My name is Micah Pierce. I'm also a resident of Contra Costa County. I want to echo what the rest of my fellow residents said, as well as remind everyone that usually positions like county clerk go uncontested. So we don't even have the normal ballot procedures to protect against violations like this. So your work is basically the only thing that serves as a deterrent. So to allow a deal and a stipulation that lets the offendant get away with paying half of what was levied in the first place, which was too small, isn't as much as a deterrent as we would like to see in a system where we have very little other recourse. Thank you.
Thank you.
Hi, I'm Rebecca Auerbach, also Contra Costa resident, and my mom, also a Contra Costa resident who never comes to meetings with me, came up to this one because we were both so deeply disturbed about what we've learned about our clerk recorder, and that this, the person that actually oversees our elections process would be so corrupt is terrifying. And as others have said, I would like to urge you to reject the settlement and to pursue this in the strongest and most public way possible. And that this needs to be a matter of the greatest public disgrace to discourage others in the system from following this example. And I really appreciate your research. I appreciate that you are concerned about the matter, and I know that going after it farther is going to be a great big pain in the neck, and I think it's just such a matter of great importance. And I think about, yeah, he's supposed to pay $75,000 out of his personal funds, and that sounds like a lot of money until I realized that one of the matters in this investigation was this person spent $36,000 on a single vacation. $75,000 isn't that much to someone who's spending money that way, and just push this as hard as you can because this undermines our democracy. Thank you.
Thank you. Any further public comment in person? Seeing none, I wanted to recognize that we did receive a digital comment from a Contra Costa resident who suggested that we consider having Mr. Cansamia pay the penalty in full. And I wanted to give the opportunity to Chief of Enforcement West to explain to the public why it is that certain counts, Mr. Cansamia has to pay those personally as opposed to others under the statutes.
Certainly. Galena West, Chief of Enforcement. The statute was changed January 1st, 2015, and before that, you could pay it all with campaign funds. And so then the legislature determined that there were certain violations that would need to be paid with personal funds. And that's why those are the ones that are charged, and we make sure that that comes out from personal accounts. And then addressing some of the other issues, we agree. This is why we spend resources on this. This is why we publicize these cases. We get them in stipulations. We get the facts known. No one knew any of this before this stipulation was published, and now everyone does, and they can vote with information, which is the whole point of what we're trying to do, is get the information to the voters. And Mr. Cansamela did resign, but the whole point of trying to do settlements and stipulations and get notice out to people and get stories told is so people know what's going on in their jurisdictions and in their neighborhoods. And so I feel like in this case we did that with an appropriate amount of fine, and he paid back the entire $130,000. So I do believe that the make it painful portion has been achieved. And unfortunately, we have no jurisdiction over pensions.
You did mention earlier, you had referred this to the DA, though, so there is the possibility that there's further criminal action.
We have.
Pending the DA's investigation, of course. My question for you is, have you considered, or in the past, have you referred these types of matters to CalPERS? You are correct. This is anything related to a pension is obviously outside of our jurisdiction, it's likely within their jurisdiction. Could we refer this over to them so that they can investigate to the extent that they have the ability to do so?
We haven't done that in the past. Complainants normally do, as I think Commissioner Hatch has suggested in the past to certain complainants, maybe even Mr. Vaughn. And but it is something that we could do as a practice when it comes to employees that are receiving pensions.
I'm wondering if my fellow commissioners would join me in making that request with respect to this particular item.
If I could shed a little light on this retirement issue.
Hang on a second, Commissioner Hatch. There's a question pending, so why don't we finish that first?
I think it sounds like a good idea.
Commissioner Cardenas?
By all means, Mr. Chair.
All right, Commissioner Hatch, the question was whether or not we wanted to have Ms. West refer this to CalPERS for additional investigation.
In this particular case, Mr. Chairman, there's a county, Contra Costa County Retirement Board is a part of the 37 Act system, would be the appropriate agency to contact.
Okay.
Okay. That sounds like, Ms. West, that we have consensus for you to do that on this item.
Okay.
Sorry, Commissioner Hatch, I think you were going to make an additional point.
Oh, didn't that come through? Sorry. I was saying in this particular case, it would be the Contra Costa County Retirement Board that should be contacted because it's the county participates in the 37 Act system, not CalPERS.
Okay, thank you. All right, any additional public comments on the consent calendar? Any additional commissioner comments? Seeing none, we have a motion.
Are we going to separate anything out for separate consideration? Because now I want to.
The motion was to approve the calendar in toto.
I want to talk some more about Consiamia.
Okay.
I thought about this for some time and tried to understand as best I could how this has been positioned by our staff, which I think represents good work. But I'm not sure it represents justice. I was completely fine with holding my nose and voting for item number 3 as positioned for us, but that was before I heard this particular politician's constituents speak. It was suggested a few minutes ago that this goes right to the heart of our democracy, and that strikes me as being sadly accurate. And, you know, at the end of the day, maybe our democracy, like other threatened institutions of our civil society right now, is only as strong as its foundation. The foundation of democracy in this country has perhaps always been nothing more than faith. That armed with the right information in an environment that values transparency and disclosure, that we will be able to exercise our sacred franchise and do the right thing. Elect good people who have our best interests at heart. And that doesn't seem to be very prevalent to this observer anymore. When someone leaves the ranch with such abandon as this person, Consiamia, all the other cows on the ranch need to be advised that this cannot happen without some hellacious recompense. And so I have to ask Ms. West, what more can be done? The work here by the staff is good, but the people are asking for justice, and we have got to find our way to that daylight, because there's just too much distrust in this system. And I can't be a part of a process that adds to that in any way.
I find everything that's been said to be compelling. It's true that we are doing what we can with the administrative law that we have. And we make the referrals to the criminal law enforcement, and we'll make the referral to the pension. So we do what we can with our piece of the world, and there has to be some value in settlement. Otherwise, enforcement will shut down. If we have to take every case to hearing to get the maximum amount of fine, then we will have nothing. We will have no justice. We will have no cases where the story is told. We will have no resignations. And so you have to strike that balance, and that's what I feel like we did here. And so for me, I understand the frustration, and I also understand that we only rule the Political Reform Act, and that's what we look at and what we enforce. And we prioritize these cases, we prosecute them, we get the information out, we publicize them, and that's what we can do in our slice of the world.
All right. We have a motion. Ms. Linker, would you like to call the roll?
Commissioner Cardenas?
May I invite any other comment that might be had in this regard?
Commissioner.
So, Ms. West, what happens to the tolling agreement if we reject this step and it goes to a hearing?
The tolling agreement is the ability to cancel it with 30 days notice by either party.
Okay.
The filing of probable cause would need to preserve counts.
As I understand it, Ms. West, just to summarize, you and your staff have done everything you can to the fullest extent of our administrative authority. The fines are maxed out. We have extracted an agreement to repay or to pay the fines with personal funds to the extent that the law permits us to. You've made a referral to the district attorney for criminal actions that are outside our jurisdiction. You're going to be making a referral to the pension trust on matters outside our jurisdiction. And in your judgment, there's simply nothing left for us to do at this point. We have done everything we can.
Certainly, and that's all true. And to Commissioner Hayward's point, without that tolling agreement that Mr. Canciamella did agree to, these counts could not have gone back this far because of the statute of limitations. So there was a level of cooperation in this case that we did take into consideration.
Now, to the extent that we have done everything that the law currently allows us to do, this commission could, of course, as part of its legislative calendar, request that the legislature perhaps consider upping the fines that we can levy for certain types of violations, including personal use. And given what I've heard today, I think that may be something that for my colleagues to consider us requesting in the future. But as to today, it seems to me that you've done everything and a great job at that, getting us to this point. So unless there's additional commissioner comment, I'm inclined to call the roll. Please.
So this goes from the legislative, it's in the executive, now it's going to go to our third branch. I will vote with my colleagues presumably to approve this, but I will say this. This commission will consider requesting the legislature to enhance and grow this fine so that future consumias, and Lord knows there will be, will pay an even steeper price. Let that be the legacy of what he has done to you and the effectiveness and the power of your voice here today. That's the most I think we can offer, but we offer it with heartfelt appreciation to you.
It's well said, Commissioner Cardenas.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Manich?
Yes.
The motion passes.
Thank you. And thank you to everybody who traveled from Contra Costa today. We appreciate you coming and talking to us. Thank you. At this point, we'll move on to item 16, adoption of the 2019-20 SEI Form 700 and related documents. We have Supervising Attorney Suki Brar here. Good morning.
Good morning, Chair Matich and Commissioners. I'm presenting the 2019-2020 versions of the Form 700 reference pamphlet, Form 700U, and Form 700A. We update these documents each year with the new dates and any needed changes as a result of changes in the law or regulations. We noticed these documents for a 30-day interested persons comment period on October 2nd. Changes as a result of any comments received are highlighted in green on the documents that were posted. And with that, I recommend the Commission approve these updates.
Any Commissioner questions or comments?
Yes, I noticed we got a comment from somebody, and I'm not quite sure I understood what their objection was. I think it was that when you're using the Form 700 in PDF form, it repopulates in a way that's really awkward. Did you have, was that a helpful comment? Is there something we can do about that?
Yeah, so the comment we received from Pamela Shepard was that when her department added extra pages to the PDF we provide on our website, it would populate when she entered something into one schedule and they added another page, identical page, it would automatically populate into that second page. So it's not something we produce, it's something that they were adding to it. But I actually reached out to her yesterday for a workaround to that. And basically what the workaround is if she adds extra pages before entering information into the PDF, then it won't populate onto the second page. And I asked her to let me know if that worked for her, but I did not hear back from her. So if I hear back from her, I can let you know, or we can see what happens. But I'm hoping that it worked for her, and that's why I didn't hear anything. Yeah,
that's why you didn't hear anything more. And so, yeah. Okay. Well, no, I was just, when different people have different systems in different offices, there's going to be irregularities, and it's good that we could figure that out for her.
Okay.
Any further Commissioner comment?
A question.
Commissioner.
If she were filing online on behalf of her member, this issue would not arise, correct?
Yes, that's correct.
Okay, thank you.
Is there any public comment on item 16? Seeing none, do we have a motion?
I move for adoption.
Second.
Ms. Linkert, call the roll.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Chair Manich?
Aye.
The motion passes.
Moving on to item 17. These are the updated campaign manuals and lobby manual. Again, we have Supervising Attorney Ms. Brar.
Okay, I'm presenting the 2019 changes to manuals 1, 2, 3, 4, 5, and 6, and the lobbying manual. These manuals have been updated with current contribution limits as well as other changes in the law that went into effect in 2019. These manuals were noticed for a 30-day interested persons comment period on October 15th. Any substantive changes made since the manuals were noticed are highlighted in green. And I also wanted to note that Commissioner Hatch reached out with a couple of minor changes. One of them was that in Manual 4, there was an instance where the word disclaimer appeared, and that should have been disclosure. And that's Manual 4, Chapter 9, on page 9.1. So we'll be making that change. And then the other change is that the published date for these will become November if the Commission adopts them today.
Did we receive any comments from stakeholders prior to today about the manuals?
No, we did not.
Mr. Bainbridge?
I think he was teeing us up there. Yes, we got a compliment from someone in the regulated community, Brian Hildreth from Bell McAndrews, Hilltac, complimenting us on the multi-purpose section of the regulation, which has been worked on over the years. So Trish Mayer, who was a longtime employee here, I think did a lot of the heavy lifting, and Tara, who's now in the enforcement division. So we'll give them credit for their hard work. And if you don't understand multi-purpose organization rules, welcome to the club, and we have a manual that will try to help explain it to you.
Thank you, Mr. Bainbridge. All right, any commissioner comments on this item?
No.
I have one question. Sorry, oh, wait.
You're up, Commissioner Hatch.
Okay. In reviewing these documents, it sort of reminded me that the ratio on the limitations for voluntary contribution limits between the Assembly and the Senate seemed to punish or to overly limit the Senate as opposed to the Assembly. And it may be that there are other relationships that are not done. When these were set in statute and continue to be a long time ago, before much experience was available to value what these relative limits should be. I was curious with who would be charged with studying that information and making recommendations on any changes to those ratios.
Ms. Brock.
The legal division can do that in consultation with the ledge director and the commission.
Okay, then if we find that there's a reason to, we could recommend to the legislature that they consider legislation to change those ratios.
Yeah, we can look into that.
Okay, great, thank you.
How do other commissioners feel about that?
Sure.
I think Commissioner Hatch, I'm going to try and summarize your request, and please feel free to correct me if I make a mess of it. Your question has to do with the ratio between contribution limits for Senate and Assembly candidates, and the question is whether that ratio should be adjusted in some way based on experience. Is that accurate?
Essentially, yes, and we're speaking to the voluntary contribution limits, you know, the aggregate amount of money that they can receive and still be under the voluntary limits. The ratio currently is such that the Senate limit is 130% of the Assembly, and I think there was some presumption at the time that they didn't need that much more money, but I think we might be surprised if the results of the investigation into it.
All right. I think, does that clarify, Commissioner Cardenas? All right. So it appears that we have a consensus to have staff perhaps come back to us at a future meeting with recommendations on that issue. Mr. Bainbridge.
Great, thank you.
We could include it as part of the legislative show next in December, I think, is when it's coming up, proposed legislative action. So it could be included as part of that presentation, if that makes sense.
It does. Do you think that you could, as I understand it, Commissioner Hatch, he wants to study whether there's a need or a justification for the change. If your staff thinks that they can complete that before making the proposal, I think that's fine.
Okay, yeah, well.
Yeah, that would be good. I would think that we'd want to look at competitive races to be able to get an idea of what the spending patterns are. And I don't know what amount of time it would take to do that.
Yep, I take back what I just said. It won't be ready by December. But we'll, with the study involved, yeah, we'll look into it and bring it back when we have something.
Okay, thank you.
Thank you very much.
All right, with that, is there any additional commissioner comment on item 17? Seeing none, is there any public comment on item 17? Seeing none, do we have a motion?
I move adoption.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Matich?
Aye.
The motion passes.
Thank you, Ms. Barr. Moving on to item 18, These are amendments to Regulation 18450.1, advertisement disclosure and regulation, 18435, mass mailings, 18450.2, authorized and paid for, 18450.3, and 18450.4. And we have Council Ms. Harrison. Good morning.
Good morning. Good morning. Thank you for reading that long list for me.
Yes, you've been busy.
It's a mouthful. Karen Harrison, Senior Commission Counsel. I'm here with my colleague.
Hello, Kaylin Green, Commission Counsel.
And we are here to present the proposed regulations and amendments related to campaign advertisement disclosure requirements. Through the interpretation process of this Disclose Act, staff has identified areas that can be clarified through the regulatory process. Substantively, staff is proposing amendments to Regulation 18435, the mass mailing regulation, to clarify disclosure requirements for mass mailing. This specifically relates to advertisements, mass mailings of a personal nature sent by a major donor committee or an independent expenditure committee, and mass mailings that are non-monetary contributions to a committee. We are also proposing 3 new regulations for adoption. The first regulation, 18450.2, would define the phrase authorized and paid for as used in the definition of advertisement. This relates to issues of multiple committees, non-monetary contributions coordinated with a committee, and electronic media advertisements with nominal costs. We're also proposing 18450.3 to clarify top contributor disclosure for major donor committees that qualify as top contributors by virtue of affiliated entities. And lastly, a regulation to address the length of a disclosure for a video or television advertisement lasting less than 4 or 5 seconds. The proposed amendments and regulations were presented for pre-notice and direction at the September 2019 meeting. The proposed language before you today reflects informal advice, input from the public, and comments from enforcement. They are now presented to you for adoption with 1 or 2 comments. On 18435 on line 10, we would like to change the word communication to mailing to be a more exact term. And I would also note that we did receive a comment on 18450.2 from the law firm Olson, Hagel, and Fishburne prior to the meeting, requesting the addition on line 5, the language full costs of. On that particular change, staff's considered it. We don't see this as especially necessary, but if the commission finds that it clarifies things, we don't object to that additional language. With that, we present it to you for adoption and approval.
Thank you. Commissioner comments?
I'm sorry, I missed the last.
Sure.
Was it line 5 of which?
Line 5 of 18450.2.
Mr. Chairman?
Yes, Commissioner Hatch.
If there are no objections, I would move that we accept the proposed amendment.
All right. Well, Commissioner Cardenas, were you finished? I know you had a question.
Yeah, that helps. Thank you.
Okay. Right. Commissioner Hatch, you're recommending that we accept the proffered change from the Olson Hagel law firm. Is that what I understand?
Correct.
All right. Is there commission discussion on that?
I think it's clarifying, actually. I think it's a good edit.
All right. All right. So then, do we have a motion to approve the amended regulations with the caveat that we accept the amendment recommended by the Olson Hagel firm? Is that the motion?
Yeah, that'd be fine.
All right. Do I have a second?
Second.
All right. Is there any public comment on this item? Any further commission comments?
Can we ask staff if they have a position? Did you speak to that already?
Yes, we said that we had no objection if the commission felt that it was appropriate.
Okay. We have a motion. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch? Commissioner Hayward?
Yes.
Chair Matich?
Aye.
The motion passes.
Thank you for your hard work on this. Item 19 is the update on the Digital Transparency Task Force, and the update is Commissioner Hayward and I will be discussing this shortly, and we will report back at the next meeting on it. Moving to item 20, this is a memo regarding gift rules and college scholarships. By way of background, Commissioner Hayward had raised an issue, I think last meeting, in response to an advice letter that we considered. We asked staff to provide us with some additional context and information on the rules. And so today we have Assistant General Counsel Brian Lau to walk us through his memo.
Hello, I hadn't planned a full presentation walking through the memo, other than just stating that we tried to answer the question that we believe was before us, which was trying to further answering the question of whether or not there's a distinction made between scholarships that were offered, merit-based scholarships versus any other scholarships, and we try to walk through the appropriate law that we had considered in drafting the Hicks letter. So if there's any questions, I can attempt to answer them from there.
All right. Commissioner, comments?
Yeah.
Commissioner Hayward?
I think, nothing in the memo is wrong. It's just, it kind of talked past the concern I was trying to raise last month. And that's not your fault. I probably wasn't as clear as I could have been. I've, just for everyone else's knowledge, circulated a Wall Street Journal article from last year that talks in great detail about the practices of admissions offices and how, the ticket price to college is rarely paid, the same amount is rarely paid by, like, your neighbor or you. They have all sorts of formula they use to figure out how much money they need to provide as a discount in order to get a particular desired student to enroll. A lot of that's very sort of hush-hush because you don't want to tell the competition what you're doing. It's almost like a trade secret. And I was looking at this as the position of somebody who has one kid in college and one kid who's going to be there shortly, and thinking that if I am a person who is filing a Form 700, oh wait, I am, I'm not going to look at that merit aid as income. It's just sort of like if you pay less than the sticker price for a car, you don't think of the difference as income. You just think of it as a price. And so I guess what I'm struggling with is coming up with a rule that has that, keeps those sort of arm's length market transactions out of our system, because I don't think we're going to be, I think it's just going to be a trap for the unwary. Or even a trap for the wary. I mean, it's really confusing when people get scholarships for tuition and books. It's not taxable income, and if we're thinking that having that scholarship, reported as income on somebody's Form 700, a lot of people just aren't going to be able to do that. So anyway, so what I'm struggling with is trying to come up with an interpretation that keeps those sorts of arm's length market scholarship offerings out of our system, but still allows, because as we've seen in the admission scandal, colleges are not above getting corrupted by people, so that those can be treated as gifts or income or whatever would be the appropriate thing we would do under our conflicts rules. So that's where I am right now. And I don't know if I'm the only person that's sort of charged up about this. I'm happy to sort of let it go. But if it seems like an appropriate time in history to look at this, I'd be happy to work with the legal division to try and come up with something that I think keeps the people who don't need to be part of our world out of there. Does that make sense? I hope I'm sort of articulate this morning.
Can I just try to summarize? So the types of, I was going to use the word scholarship, but maybe that's not the right word, but it's a tuition discount that in general is offered to all or most of the incoming students. Is that the scenario that you're referring to?
There are many universities where upwards of 75% of the attending students have some sort of merit aid. And let's just say, not all of those kids were the valedictorian 800 SAT merit students. They wanted to recruit a certain kind of profile of a student body because they've got a mission that they're trying to succeed with, and they have figured out how to, how much they have to offer of a certain kind of student in order to get that certain kind of student to attend their school rather than somebody else's.
Okay.
And this is going to get, I think, weirder as we see the crash in college-age enrollments. It's going to happen in a couple of years, and there's going to be a lot of competition for fewer and fewer students. And anyhow.
I think I understand the concept. Commissioner Hatch, I feel like you were trying to chime in there.
Yeah, actually I have other questions that are related to this, but I wanted to ask for clarification from Mr. Hayward. Are these discounts that you're speaking to disclosed to the student or the parents? Or is this an undisclosed discount that's not known to us? And then if that be the case, how would one disclose that on the conflict of interest statement?
No, the process works, at least in my anecdotal experience, in the following way. You get a happy letter from the admissions office saying, congratulations, you've been admitted to the class of 20 whatever. We look forward to getting your deposit by X date. More information will be coming to you. And then there will be another glossy letter behind that one. Maybe it has like a gold stamp on it. It's on really, really heavy, beautiful paper stock. And it says, and in consideration of your fine record of achievement, you random 17-year-old, whoever you are, you are awarded the President's Scholarship of $25,000. And all that is they're taking $25,000 off of your tuition bill. It's not something you compete for. It's not something that is something you apply for. It's just their way of trying to make sure that that particular student gets enough sweetener in the pot to enroll at their school, keep their yields high, all that stuff, and not someplace else. And so it's a different number for different people. I pulled $25,000 out of my head just now. I'm not saying that that's any particular presidential scholarship, but they are of several thousand, tens of thousands of dollars off of tuitions that are, many people think, inflated to make particular institutions look more desirable, but are in fact tuition prices that nobody in the real world pays except for maybe a few people. Does that help?
Yeah, it does help. So then we know what the discount is because it's in the form of a scholarship. The question is that scholarship then considered to be competitively attained, or whether this should be treated like some kind of what do you call it, gratuity that would have to be disclosed?
And I think that's what I'm struggling with, is a rule that will keep the sort of discount formula, ordinary, practice of colleges out of our categorizing that scholarship as a gift or income, but yet allow us, when it's appropriate, to enforce gift and disclosure requirements on people for whom the scholarship is because of their official status, or because they have particular power over something that the college cares about, or something that is more in our sort of wheelhouse than just going after discounts that are available to the majority of the public, regardless of whether they're a public official.
Well, can I ask a question? I think you said earlier, these types of discounts are not uniform. Who makes the decision as to who gets what amount?
The admissions office.
So, I think...
As far as I know, a lot of this is, one of the interesting things about that Wall Street Journal article is it said a lot of things that weren't public information, because these are not practices that colleges want to share with their competitors.
Right, but the fact remains that from what you've just described, it's not an across-the-board uniform discount available to everybody. It sounds like it's a case-by-case discount by somebody in the admissions office, we don't know who that is, who may or may not have a relationship with the family or the person for whom they're giving the discount to.
Yes, I mean, that's absolutely true. And that's, again, what I'm struggling with is how to carve out the ones that have no implication for ethics or political reform while retaining the ability to go after the ones that do.
Mr. Bainbridge, can you, or Mr. Lau, the scenario that Commissioner Hayward just described, because I think that's slightly different than what you originally addressed in the memo. This scenario where you have a sort of on a case-by-case discount provided to a student by an admissions officer, how, if at all, does that fall within our rules?
Well, I would say the case-by-case determination is more problematic because that's when you do have that opportunity to say, you're identifying the student and saying this is the award that I want to give to this particular student. The 2 points is just as far as how we try to balance this is one is very few of these scholarships are actually going to be reportable. The only instance in which they're going to end up being reportable is when somebody is receiving a scholarship from a university that has continuing activity before that official's agency. The standards are they there right now in the middle of a proceeding, or are they routinely there for a proceeding involving permits and entitlements? So it's really very limited to scholarships given from a university that's going to have ongoing and continuous business before that agency. So that's one way that we've tried to narrow this down and only get to those scholarships where there's some sort of indication that that there might be something going on there as far as who's receiving the scholarship. So I would make that point. And the second point is if there is a scholarship that I believe I actually had one at one time that I was told that everybody that had over a 3.0 received this same $1,000 scholarship. When there's no discretion, when it's something across the board, if a university had a policy that everybody with the SAT score over this amount will get a $5,000 presidential scholarship from us, those types of things would be just a discount offered in a regular course of business and not be reportable at all as well. So those are 2 ways that it is narrowed, kind of trying to address some of the concerns that you raised.
So in other words, if my son was, and we live in Southern California, if it was a Stanford offer, we could assume that it would not run afoul of this regulation, the existing regulations. But if I was a city councilman in Palo Alto, that may be a problem with a Stanford scholarship.
Yes, that would be correct.
Do we currently, with respect to our informational materials that we make available to the public, highlight the distinction that we're drawing here today between the sort of across-the-board uniform discount and the case-by-case reduction in tuition?
I don't think on this specific issue. We haven't ever considered the issue that Commissioner Hayward had put forward, which is why we weren't really thinking of that when we produced this memo. The question of whether this doesn't even qualify as a gift because it's given in the regular course of business. We have given advice, and I assume our manuals talk about that in other contexts. It just hasn't come up in this context.
Yeah. I mean, I think given the Commissioner Hayward's point, I think is well taken that this is becoming a more prevalent way of providing discounts. At a minimum, we ought to insert something in our informational materials to alert people to this. I also have, this may be sort of a random question, but I'm going to ask it anyway. Do we have any ability to communicate or request that universities that offer these discounts include some type of a notice? Just, we're providing this discount on a case-by-case basis. If you or a family member are a public official, you should check to make sure this is reportable or not on your Form 700.
I mean, that's one of the problems is that we have the official coming to us and they're not often going to have that information in order to determine whether or not there was some sort of individual consideration of that student or not. But I suppose if the actual university came to us as far as we want to provide this kind of scholarship, it comes to our attention that some of these go to governmental officials, here's our process, here's our standard, this is how we do it, this is how we leave. We want to ensure that we're not giving an unlawful gift to these officials, then maybe we would have that information before us. So in some circumstances, maybe we would, but it would be hard for us to get it as far as when this the official coming to us and asking, is this something that I have to report as a gift or not?
Yeah, no, my point is more working in collaboration with the universities who are using this practice to just provide some basic notice when they transmit notice of the discount. Commissioner Hayward.
Yeah, and I think, just having this discussion we're having today is going to raise the profile on this question a little bit. If it's the desire of the commission, I'm happy to sort of let this sit for a while. Sometimes these standards are harder to develop and harder to think about when you don't have a particular matter before you, and when we're talking in vague generalities about practices that are not uniform. Or if it's the interest of the commission, I'd be happy to work with legal to do some more head scratching on this. It's kind of up to you guys. I don't want to beat a dead horse. We've got a lot of other things to do. We don't need this because we're bored. But I think it could conceivably be important.
Commissioner Cardenas, did you have some?
I think it's a fascinating nuance that's worth exploring, and I'm glad someone's doing it because it's not something that I'm particularly equipped, perhaps, to engage in. But I respect your willingness to do it, and I hope you don't stop, because I still don't know what the answer is.
I'm not sure I do either.
Commissioner Hatch.
Yeah. That questions unrelated to the issue raised by Commissioner Hayward as well. On page, and this is not too long in the memo, I just raised questions in my mind. On page 3, paragraph 1 of our regulation that's quoted on that page, it seems confusing to me. It describes a familiarity relationship that sort of seems counterintuitive. So you're somebody with a relationship with the grantor, but yet it's not subject to the disclosure as a gift. I think if you get to that point where you were to make some changes, I think that could do some work. And it also, reading this raised question for me, that a lot of organizations and, in fact, companies, the scholarship programs often that they administer, but they usually do that through a 501c3 foundation charity that administers the grant programs. Is there, have you even run across this? So let me give it hypothetical. Let's say my wife works for IBM. I think they're still in business. And IBM has a 501c3 charity that they administer, among other things, a scholarship grant program for children of longtime employees of IBM. And so the scholarship is awarded to, say, my son because of the relationship with my wife who works for IBM. Does that meet the requirement that it's income rather than a gift? Or is it something that we've not really looked at before?
Well, we've had similar situations pop up, and that something like that, where there's a relationship with the employer, and that's why they're providing the scholarship. Those types of things, they're considered gifts to the student as opposed to a gift to the officials. So those types of scholarships are not reported as either income or gifts. But in that case, it would be coming from an employer, so it could be. So I'm sorry, that could potentially be a income reportable as income to the official. I haven't seen one actually given to the official's children, but I have seen one given to the actual official themselves, the official spouse. So those types of things, it's just it would fall into the category that if it was to that family member who had the relationship with the employer, as opposed to something to the official. And whether or not that makes it reportable depends on whether or not that's income or a gift at that point.
So it's that in that example would not be a gift, but maybe an income requirement.
Right, that would not be a gift to the official. That would be subject to any kind of limit or reporting as a gift.
And that would only arise if it was in a jurisdiction, if the IBM in this case was in office in the city that I was a city councilman in.
Well, yeah, I guess I should have qualified that, because if IBM is before you on any particular matter at that moment that they're given the scholarship, or if IBM is regularly appearing before you, then correct, we would, the regulation, the other provision of the regulation would apply, and there'd be thus evidence of intent to influence the official, so it would be considered a gift to the official.
Sort of bottom line, as I reach it, because it is kind of confusing. In virtually all cases, you either have to report it as income or as a gift. Is that right? Are there any instances where you would have no obligation to report either?
This is a little random, but I think there could be some opportunities where you wouldn't report anything, because I just do recall an incidents where a high school coach was trying to give some money to a student to go to college, and we said that it wasn't formal advice. I think it was a telephone or email advice, but I believe when we looked at that, it was a gift to the child, no income to the parents at all. So that was a nothing.
Okay, thank you very much. Appreciate it.
All right. Any additional commissioner comments on this? I guess one thought that I had is that perhaps what we can do, I think there are two things that I propose that we do. The first is I think we should develop a standalone, just real basic one-pager on how scholarships and financial aid are treated under our gift rules and conflicts rules, et cetera, so that a public official can go to one place and quickly sort of get the lay of the land on what the rules are under our current rules. And I would suggest that we address the types of scholarships, discounts that Commissioner Hayward mentioned among the other items that we consider in that informational bulletin. And again, something very basic, one-pager, give them the basic lay of the land. Secondly, I do think it may be appropriate for Commissioner Hayward to continue having a dialogue with legal division about some potential changes to this reg, and whether we need potential changes to address this, and then come back to us at a future meeting if we decide that there is such a proposal that we need to consider. So those are the two things I'd suggest. And I will just say that's a motion. Do I have a second?
Second.
Yes, forthwith. Second.
All right. Ms. Link, a public comment. Seeing none, hearing none. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Manich?
Aye.
The motion passes.
All right. Thank you very much. We'll go ahead and move on now to item 21, Chief of Admin Larissa Hahn, and approval of Commissioner compensation request.
Good morning, Chair and Commissioner. I'm here to request the Commission approval of Commissioner compensation as submitted.
I had a question. The reimbursement request appears to be from July. Do we have we have a, like, what's our process for submitting reimbursement requests, I guess is my question.
I think our internal policy that based on the commission manual, we told the commissioner themselves that we should get the request ASAP. Once they pass the month, they should submit the request, but there's no time limit that's set forth.
Okay. All right. I just wanted to, I didn't know the rules, so I just wanted to ask. Any other commissioner comments? I think he's already out of the room. All right. Any public comment on this item? Hearing none, I'd move approval.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch? Commissioner Hayward?
Yes.
Chair Madich?
Aye.
The motion passes.
All right, moving on to item 22. These are committee updates. Budget and Personnel Committee.
Yes. We had a call, and I did not write up the summary of the call because I forgot. That's all there is to it. We've got a first quarter expenditure report that I will swing to Ms. Hahn in a minute, except to add that, you know, it looks like we're in good shape. And we still are waiting to see how the increase in county and city contracts might affect personnel as well as budget. Now, Ms. Hahn, would you like to would you like to run us through the agenda document we have here?
Sure. The commission expenditure for the first quarter is in line with our projection that came within our based projection. If commission have any questions, I'll answer them.
Any commissioner questions, comments? Any public comment on the Budget and Personnel Committee report? Let's see. All right, let's go ahead and move on to Law and Policy then. Commissioner Hatch.
Yes, thank you, Mr. Chairman. We discussed the we discussed the issue of non-lobbyist lobbying, lobbying in effect without registering, and determined that we should request staff to schedule further input to the L&D committee for enforcement, and also perhaps a separate meeting of a regulated community representation on this issue.
All right, thank you. Any commissioner comments? Any public comment? See none. Thank you, Commissioner Hatch. Moving on to item 23, our advice letter report for November. General Counsel Bainbridge.
Give Brian a second to get up here. Nothing to say other than if there's any questions, happy to attempt to answer them.
Do we have any commissioner comments on the advice letter report?
I was just going to say.
Hey, hang on, Commissioner.
I was just going to say that to the extent people from Placer County are interested, the letter that we were talking about earlier is A19193, and it's the last one on the agenda document for this for item 23.
And just to help, if they're trying to find the letter itself, if you click on the number there you see above it listed, that'll be a link to where it is on our website.
Great, thank you. Commissioner Hatch, I think you had a comment?
Yes, I do. On item A19169, David Schwartz. This is a request at the behest of a number of elected officials at various educational institutions in Orange County. I would just say that the pro bono litigation services that would be provided does in fact confer a personal benefit to each of these politicians listed as the beneficiaries of this request, who I consider to be a part of the Orange County political glitterati that strives to hold back the working class. The nature of the personal benefit is in the form of desired political fame and recognition for anti-labor fat cat political contributors who would be anxious to further their political careers by offering them big campaign checks. The author of this advice request, despite his cleverly written content summary, is offering to provide free legal services to local politicians to strip away the most fundamental of human rights, that is the right to belong to a labor union for protections against abuses by their employers. The law that they hope to render unconstitutional for their personal gratification is as follows. Government Code Section 3550. The public employer shall not deter or discourage public employees or applicants to be public employees from becoming or remaining members of an employee organization, or from authorizing representation by an employee organization, or from authorizing dues or fee deductions to an employee organization. This is declaratory of existing law. This banal effort neither benefits public employees nor their employers. It will, however, greatly enhance the career paths of the beneficiaries of this advice request. These politicians are proposing to receive an impermissible gift in in-kind legal services of a considerable amount. This commission should not enable them with this advice letter. Let them pay for their own, out of their own pockets. I move withdrawal of advice letter A-19-169.
Thank you, Commissioner Hatch. Do we have any comments from General Counsel Bainbridge or Assistant General Counsel Lau in response to Commissioner Hatch's comments?
I think it comes down to Section 82004.5 of the Act, was our definition of behested payments. And with the adoption of that statute, they required a greater nexus to find some sort of gift to an official versus when something is a behested payment. The question becomes, is this principally for a governmental purpose or principally for a personal purpose? And I think reviewing it, I think our conclusion is that when you look at a challenge to the constitutionality of a statute without looking at that is a governmental purpose, and it falls within that category of behested payments that requires reporting as behested payments as opposed to gifts. So that's where we came out on the analysis.
Thank you. Do we have any additional commissioner comments on that? All right, Commissioner Hatch, you've made a motion. I don't hear a second.
Yeah, just before they consider a second, I just indicate that this law that hoping to challenge has been on the books for decades. It's well established in the Constitution in California that workers have rights. And this is purely a political move, not one of and as a matter of fact, each of them have an obligation to follow the law, not to try and find a way to get rid of it. And I just don't think that we should be their enablers. If we withdraw this advice, then they're on their own. I suspect that if we didn't offer them the sheltered advice, that probably the pro bono legal work would probably dry up as well. It's just wrong.
Commissioner Cardenas?
Commissioner Hatch, it's Frank. What's our understanding of the nature of this this proposed pro bono legal service? Do we know? Do you know?
Well, from the from the lead end, the requesters through their attorney are elected officials from various educational institutions in Orange County, and they're out to attack the right to not be molested by the employer. This is You would not get this from the description that was offered by the requesting lawyer, but in fact, that's what this is about. They want to get the Supreme Court to hold that this law is unconstitutional. And the likelihood of success is minimal, so that makes it even more of a political ploy to raise their profile in Orange County politics for higher office. Does that answer your question?
Yes, thank you.
All right. These are attacks directly on teachers in all levels of education in the Orange County area. It's community colleges, high schools, and the like. It's an abomination.
Do we have any public comment on this matter? All right, seeing none, we'll go ahead and move to item 24.
No, wait. Did it die already? Did the motion die?
I called for a second, nobody seconded.
Oh,
Would you like to second?
Yes, yes. Second.
Thank you.
With my apologies for my slowness, yes, I second Commissioner Hatch's motion.
Go ahead and call the roll, Ms. Linker.
Commissioner Cardenas?
On the Commissioner Hatch motion?
Yes.
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
No.
Chair Matich?
No.
The motion is tied.
Mr. Brainbridge, can you remind us what happens when we have a tie motion?
Yeah, the motion was to resend the letter that has already been sent out. So since there wasn't 3 votes on it, the letter remains as a letter that has been sent out and is not rescinded.
All right, thank you. All right, moving on to item 24, our executive staff reports. Chief of Enforcement West, would you like to go first? All right, you're up.
It sounds like you have a lightsaber in Hawaii. Thank you, Galena West. Normally my reports are as submitted, but there has been some public comment on one of the streamline items, so I thought I would discuss it. It is the Todd Gloria case, and there seems to be some confusion as to the allegations and what's been proven by enforcement and come to a stipulated settlement. And I would just say that we did look at everything that was alleged in the complaint as well as in the referral, and as well as in the self-reporting. And although we agree with some of the sentiments about the lapses in the existing law about candidates being able to have multiple committees and fundraise, it's not really the issue in this case. The issue of whether or not the law should be strengthened in some way is not what we were looking at. We were looking at what were the existing rules and what did Mr. Gloria failed to do, and what that was he failed to timely file his 501, which is his statement of intention, and he did timely file his Form 410, which, as we know, is how you form your committee. And on that report, all of the information was reported. So it reported the office he was running for, the name of his committee, the other committees that he had open, the bank account information, and all of this was filed timely. And then it was also amended to update this information timely. And then the 460 that was due was also filed timely. Looking at the contributions that were received, we did take a look because some of the allegations were for laundering, and most of the money that was raised, 90%, will not be able to be used by Mr. Gloria because San Diego, in his San Diego mayoral race, because San Diego's rules are different, and they say as candidate you can only receive contributions from individuals and political parties. So about 90% of the over 300,000 will not be eligible to be transferred to his mayoral campaign with the attribution. So we looked into all of that, and I believe the complainants had also referred this to the district attorney's office, which would be the correct purview for allegations of perjury, and not ours. So we applied the streamlined criteria as we would in any case in the regulation. And one of the very prominent factors in the streamlined criteria is the information disclosed on another statement filed by the person in a timely fashion? And the answer to that is yes. So even with 24-hour reports, which have very strict rules under the streamline for when you qualify for streamline, if it's reported on another report before the election, in this case, before anything, then that's taken and given great weight to qualify for the streamline program. So we, just to answer all of the questions that were out there, that this case was handled under the streamline criteria as approved by the commission.
Thank you very much, Ms. West. Do we have any commissioner comments?
Thank you, Mr. Chair. My pulse rate goes up when I see the amount of money that was in that particular committee. But it's by virtue of San Diego municipal public finance regulations that this individual cannot transfer what, any more than?
About 10% is what it works out to be. About 10% of the money is, this is just a quick review of us because we were trying to trace the money because one of the allegations. So we found that about 10% of the money would be eligible to be transferred.
That's by virtue of their local enactment,
right?
At least in that particular regard, which is more stringent than what the state regime.
Quite a bit.
Otherwise, well, kudos to the people of San Diego for having done such a thing. It's been suggested that this was a self-reported.
It was both. So Mr. Gloria self-reported it, and the complainant filed a complaint. I believe it was a couple days later. So we received it from both means. And then the only other thing that's been brought up is that the penalty is incorrect. But since the 501 and the 410 do not actually have amounts on them, there is no percentage bump for charging for those.
All right. Thank you. Do we have additional commissioner comments for Ms. West? Any public comment for Ms. West? Seeing none, thank you, Ms. West. And we'll be seeing you tomorrow for the enforcement extravaganza.
Yes, and we'll actually talk about streamline tomorrow. So
Enforcement Palooza.
Yes, there you go. That is tomorrow.
Is it 10:30? Is that the start time?
Yes.
Yes.
10:30? Oh.
All right, thank you. Mr. Bainbridge, would you like to give us your report?
As submitted.
Any questions from the commissioners for Mr. Bainbridge?
Is that a request or a promise or?
Both.
All right, seeing none. Any public comment on the legal division report? Seeing none. Ms. Hahn, would you like to provide us with the administration and technology division report? Or Executive Director Jones? Ms. Hahn is listed on the agenda, but Executive Director Jones, I imagine you could do this as well.
I'm happy to chime in. I have three brief points. The first one arose today. It dawned on me that the commission may not know, when we get public comments from the public prior to a meeting, if there's an additional issue in there that we think we can work out at the staff level, we obviously try to work that out. And oftentimes, it dawned on me today, you don't see that here. But quite frequently, when we get public comments, we will reach out to them to see if we can resolve whatever issue they have at the staff level. But we still keep their comment in so that, I mean, they want to speak to the commission directly, and we keep that in there. Number two, we continue to work with the localities on contracts. We didn't expect that this was going to be a pretty or smooth process, and it has delivered on that promise. There's a lot of quirky rules and procedures and politics at the local levels that we're hashing through. But right now, we have one locality that has it pending before their Board of Supervisors, one county that is supposed to deliver at this week, and one city that is planning on delivering it to their governing commission in January. The third thing I wanted to highlight is by way of transparency and technology, just to update the commission on several things that have been going on, largely with the leadership of the chair and with the assistance of Larry Crabtree and his IT group. You have the text participation that we are encouraging people to use more frequently. We have, just this past month, added audio files for all of the committee meetings so that those are available to the public. We are exploring the possibility, we were alerted that the state of Georgia uses a real-time chat bot during working hours that you can, in lieu of calling on the phone, put your question into a virtual assistant who's really a real assistant on our end, but they don't see that.
So like one of those, hi, I'm Daniel, can I help you?
Yep.
Wow.
Yeah. There are some both technological and staffing issues that are arising, but we're figuring out if we can work through those. We are, as I may have reported before, we're working on short, focused videos for the website for the next election cycle, so that rather than taking up a half hour of somebody's time on the phone, they can watch a 1-minute video on a very specific topic that they're looking for. And starting with today, the video of today's meeting will be posted with bookmarks on the left-hand side, so you don't have to scroll through the entire meeting to find what people are talking about. It'll be per agenda item, so you'll be able to find things. And we continue to tweak and try and improve both the transparency and the ability of the people to participate at meetings. So if you or members of the public have ideas in that regard, we're very open-minded at this point. And with that, that's all I have to report.
All right, thank you. And I just want to recognize Executive Director Jones's work, both on the transparency aspects he just mentioned, but also on the contracts. There's a lot of work that goes into it. It's important work. I know we're trying to expand our collaboration with local governments, but I wanted to give some props to the Executive Director because it takes a lot of time. I know you're working hard on that.
Thank you.
So, other commissioner comments?
I'm sorry. I apologize. Does that include outreach and training? Or is that a different, did I miss that?
I have, for today's purposes, taken the load off Larissa, so I can address any questions that you have with regard to IT administration.
Oh, I apologize. I'm sorry, Mr. Jones. I think that was under legal. The outreach and training by our political reform consultants up and down the state. Is that?
We are, I mean, the long-term plan that we have is to gradually expand our ability, and just taking a step back, part of the reason that we want to enhance the information and the ability to access information on the website is to free up time within our education division so that we can roll out more boots on the ground type training. You may recall that as part of the template contract that we offer to municipalities, one of the required provisions is that they do an introductory course from us on conflicts of interest, not with respect to their local ordinance, but generally on conflicts of interest. It's our view, or at least mine, a very strong view, that by promoting and building an ethical culture at the local level, we can sort of hopefully lessen the amount of enforcement matters that the Commission sees long term.
Well done. Thank you.
All right, any public comment on the Admin and Technology Division report? Seeing none, at this time we will adjourn into executive session. Yes, we're adjourning into executive session to discuss pending litigation. You guys ready? All right, we're going to go ahead and go back on the record then. We've come out of closed session, and we have nothing to report out of closed session. The only remaining item is commissioner comments on items not on the agenda. Do any commissioners have any comments?
Today is as officially declared by UNESCO in 2002, International Philosophy Day. For what it's worth.
I think it's fantastic.
Outstanding. All right. Any additional commissioner comments? Hearing none, do I have a motion to adjourn?
So moved.
All right, Ms. Linker.
Waiting for Brian a second.
I'm seconding.
Oh, sorry.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Not sure he's there. Well.
You already did.
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
All right. Thank you, everyone. We'll see you tomorrow.